Good afternoon, everyone. Thank you for joining today's session on individual insolvency organized by the Insolvency and Bankruptcy Board of India, Indian Institute of Insolvency Professionals of ICAI, and the British High Commission. I would now request Mr. Philip Sindem, First Secretary Trade, Financial and Professional Services, British Deputy High Commissioner, for the brief background about the program.
Thank you so much, and good afternoon, everyone. As was just mentioned, my name is Philip Sydenham, and I'm First Secretary on the trade side for Financial and Professional Services based in Mumbai, the British Deputy High Commission there. So a warm welcome to you on behalf of the British High Commission, and it's my real pleasure to introduce today's webinar on individual insolvency on behalf of the FCDO and UK Government. We're really pleased and privileged to have later today at our event Sri Suresh Prabhakar Prabhu, Honourable Member of Parliament and former Minister and India's Chairperson for the G7 and G20. And his presence is a great sign of our collaboration in this important area. A big thank you also to those who are already here, Mr. Sudhakar Shukla, whole-time member of the IBBI, and Mr. Ashok Haldia, Chairman of the IIIPI, for joining the session and helping us put this together today. Our work together has been backed by a political commitment from both our Prime Ministers, who set an ambitious 10-year roadmap for enhancing our bilateral relationship through to 2030. India's insolvency reforms have been incredibly positive, and we are very pleased that UK-India cooperation on insolvency has been strong right from the start of the reform process. In the past two economic and financial dialogues held between Chancellor Rishi Sunak from the UK and Honourable Finance Minister Sitharaman from India, insolvency has stood out as an example of how the UK and India can work together on regulatory cooperation. Both ministers have committed to continued collaboration in deepening the UK-India partnership in this important area. In the past few years, to give a few more details, we've brought UK expertise to support the development of policies and regulations and strengthening of the insolvency regime in India, working predominantly with the IBBI and the MCA on a wide range of areas, from cross-border to personal insolvency, pre-pack insolvency to liquidation. We've supported the judiciary with their new mandates on this area. We've also delivered conferences in London to encourage international investment into Indian stressed assets. We have provided training to over 3,500 insolvency professionals as part of this programme, and over 500 creditors from leading banks in India, as well as 100 plus regulators across 19 different sessions. We've facilitated the secondment of a UK expert into the MCA and drafted a new handbook of ethics for insolvency professionals, released publicly by IBBI in March of this year. So I hope that gives you a bit of background on this project. And to repeat, our countries are committed to a deeper relationship at the highest levels. When our two Prime Ministers met at the COP26 summit last month, they repeated their commitment to deepening trade, investment and business ties, and we're really pleased that the MCA and the IBBI have ambitious plans for the Insolvency Code and looking forward to providing continued support as UK Government, sharing best practices on policy development and cooperating more closely on capacity building. So thank you again in advance to our eminent speakers, all of our panelists today who are sharing their expertise as our next step in this programme. We have a great lineup for you in addition to Sri Suresh Prabhu, and we're very grateful to all of you. Thank you also to all of you who are participating and giving up your time to listen in. I hope this will be a really insightful session and you will really gain something from your time with us. And lastly, thank you to the team at EY for organising this, along with the IBBI and the IIIPI. Now, thank you again from me, and back to EY to introduce our speakers.
Thank you. Thank you, Philip, for your address. I would now request Dr. Ashok Haldia, Independent Director and Chairman at Indian Institute of Insolvency Professional of ICAI, for the welcome address.
You're on mute.
Very good afternoon, ladies and gentlemen. Indeed, a great pleasure to be with you. on a topic which is very important, which is very critical, and for which we have been waiting for quite some time. That is the framework for individual insolvency. At the outset, I welcome Mr. Suresh Prabhu. He is going to join us soon. He is in Dhaka. He rang me up, and he would be joining us by 3:45 or so. And he has been, as we all know, he is an excellent professional, in public service for many decades, and he has acquired an aura internationally on the topic which are emerging, which are very relevant. And insolvency and individual insolvencies have been topic which are very close to his heart. I'm sure when he comes and join and address us, we will be benefited by his address. Mr. Philip Sindam, thank you very much. The First Secretary, Trade, Finance and Professional Services from the British High Commission. Indeed, a great pleasure to see you among us today. This is our possibly third or fourth program that we organize with the FCDO. Quite useful, quite interactive, and greatly helpful in capacity building for the insolvency professional and other stakeholders. I recall the program that we had on the pre-pack before the government brought out with the pre-pack scheme, a pre-package framework, and how successful it was. The participants from all over the country in a large numbers attended that programs. So thank you very much, and I'm sure our partnership with the FCDO and EY would continue to strengthen the insolvency and bankruptcy regime in India. And as you also part of the professional services, I would request you, and maybe in some time we think in terms of how to bring together the insolvency professionals in the UK and in India, and the insolvency professional institutions in UK and in India together for the strengthening the IBC regime in each of the countries. We have the member of the IBBI, Ms. Sri Sudhakar Shuklaji. Thank you very much for joining us, and your participation have always been to great advantage and enrichment of the participants. Rahul Madan and other distinguished participants and the speakers that have been lined up for the afternoon sessions. The IIIPI, as you are all aware of, is the largest insolvency professional agency in the country with more than 3,000 members, which constitutes more than 60% of the total IPs in India. And more importantly, they handle together more than 75% CIRPs in the country. And they have been instrumental in resolution of the CIRPs the last 5 years. I recall in the beginning of the IBC, everyone was concerned, or to some extent skeptical in different quarters. Do we have the enough number of quality professionals to support a complex regime like IBC, in the sense that the insolvency professionals is an amalgam of many professional qualities. It has to be a perfect manager, a perfect professional, a legal man, a finance man, a negotiator, and somebody who has the ability to bring together different stakeholders and arrive at the consensus. And therefore, we have worked all through. Can I just hold on? There is a Mr. Suresh Prabhu on the another call. I'm sorry, extremely sorry, Mr. Philip, and no, he's facing some technical problem in downloading getting connected. Rahul, with your technical team, if you can say whether he can come through the Zoom, or then I will try to see the alternative. He comes on the WhatsApp and is able to address. Sorry. So while he joins us, that's how the capacity building in the insolvency professional is key to the success of the IBC, and that is why I realize the significance and importance of collaboration between the FCDO, the IBBI, and the Triple IPI. We have been organizing conferences and seminars, strengthening the capacity of different stakeholders, increasing their awareness and appreciation of the IBC regime, and then the efficacy and efficiency in carrying through the IBC processes. Some of the important initiatives, Mr. Philip, that we have in order to fill up that gap in the capacity. No, I mean, despite the fact that they are all professionals, the chartered accountant, company secretary, legal persons, but they fall short of, the capacity capability that is required as an IP professional. So we have been organizing executive programs, 5-day programs, focusing on the industry expertise, focusing on the expertise that they need to have as a CEO or CFO of a corporate debtor or a company under stress, and also in terms of personality attributes, in terms of bringing together, negotiating, preparing a resolution plan, and creating a consensus over that. So with that, the Triple IPI is moving forward. We have our journal. All of you would have benefit of looking at it. It is acclaimed to be one of the better ones in the IBC area, and over the last 1 year, we have seen increase in the subscription or readership to a great extent. We have come out with number of research studies, which contributes to the policy thinking, which contributes to the enhances the efficacy of the implementation of the IBC and also capacity building of the IPs. The insolvency, coming to the topic of the day, so important. Everybody thought about that. Possibly, if someone is emotionally more under stress, is an individual, and particularly an honest individual, if he's faced with stress in discharging his liabilities. And therefore, one would have thought that possibly insolvency for the individual framework was first to be launched, but then considering the ecosystem in India, what was thought about was the corporate insolvency was the first thing to be focused upon. 5 years down the road, it is time now that the framework of the individual insolvencies that has been designed and captured into the IBC should be put into effect. And I'm sure in next few months, the government would operationalize it, and therefore it's right time to go through that framework, understand it, appreciate it, understand what are the challenges are involved, what are the capacities that are required to build up. It's different than the corporate insolvency in many respects, though there are similarity in legal framework to some extent. And therefore, we also need to know what is the international experiences. And I'm sure well-designed, well-structured, this conference webinar today would help towards that. And we have distinguished speakers lined up from the UK, and thank you FCDO and EY for that. And I'm sure their experience in terms of the law, the design of the law and implementation of the law and the reforms that are under contemplation in the UK would be helpful not only to the IPs and to the listeners like us in the Triple IPI, in order to help the IPs and also strengthen the IBC. With that, thank you very much, ladies and gentlemen.
Thank you, Dr. Haldia, for the welcome address and setting the background. I would now request Mr. Sudhakar Shukla, full-time member, the Insolvency and Bankruptcy Board of India, for the keynote address.
Thank you, Mr. Philip Sandram, basically British High Commission and FCDO for the opening remarks which have been made, and they are very dear to our heart, basically, when we say that credible partnership is building and we are trying to consolidate upon it. So we have seen that first phase is of the partnership got concluded recently, and we have moved on to more stronger partnership regime in phase 2. So that is a very welcome step, and you have already pointed out that 2 ministers from India and UK have aired their commitment about having greater partnerships in building the insolvency regime in India. So this is a welcome statement from your side. We have seen that FCDO and our cooperation has been much more intense in terms of orientation and much more focused in terms of sharing of knowledge, products and best practices. So these are actually, if you see the last few seminars which have happened, and voluntary liquidation got great response actually, and we are in the middle of working on the voluntary liquidation regime based on the takeaways which we got from the our UK experts in that seminar. So thank you very much for those opening remarks. I am also grateful to Dr. Haldia, because when IBC was actually announced, there was no ecosystem worth the name, and actually Triple IPI was first professional institute to come forward and take the load. And actually, if you see in terms of numbers of professionals associated with it, and also the number of cases being dealt in the insolvency space, is like they have share of nearly 2/3 of the insolvency space being handled by them. So very credible outcome and credible performance of the insolvency professionals associated with Triple IPI, and I'm really grateful to them also, because five years on, if we look back, we see that if the help from such an institute was not coming forward, perhaps we would have been struggling at the very basic level of developing professionals in India. So I wholeheartedly thank Triple IPI for its association. We have seen actually, and everybody knows, and it has been pointed out already, that IBC is a living law, and like any other economic law, gradualism is inbuilt in the ethos of rolling out. Basically, how we roll out, it is gradual in manner. It is defined in the code. If you see the section 1(3), subsection 3, it actually mentions that it has to be, everything is in the code, but rollout has to be planned depending on the maturity of the system. So we have tightened the regime around the corporate insolvency. Still, there are some spaces which we are working on. One relates to cross-border, and second relates to group insolvency. We have to complete those processes as well before we move to this subject of the today of individual insolvency. Actually, is very dear to us in the context, because we have seen 200 years of evaluation of the same in UK and also in USA about the individual insolvency. And if you see the modern English bankruptcy legislation, it has its roots in strict and creditor supportive medieval laws, but began to lose its punitive nature in the beginning of the 18th century. And now what you see in Insolvency Act 1986, and especially Part 8, 9 and 10, it's a very strong, credible regime which protects the individual insolvents. So we have to heavily depend on UK regime in the sense that not only the strong framework, but the rollout package, the debt relief mechanism, which is designed on administrative lines, is most suited to us. Basically, if we read our code, it is not an administrative arrangement, but we always think that if we have to move forward, perhaps this administrative debt relief mechanism which has been adopted in UK would be the credible way to do. Otherwise, it would be very difficult to roll out individual insolvency given the constraint at the AA level in India. So that we will be hearing today more UK regime and how debt relief mechanism works there to see that we get some insights and it helps us in moving and rolling out a better regime for individual insolvency. Similarly, and you all are aware that USA also, it all started in 1898 law, but most recent reforms, 1978, if you see, and again the 2005 variant in the name of Bankruptcy Abuse Prevention and Consumer Protection Act, a very strong ethos to save the individuals against the insolvency or bankruptcy, which is not due to their fault. So this is what has been done in USA and UK, and now gradually we are moving towards the insolvency regime in India. And if you see the framework of personal insolvency under the code, which has been envisaged, we also think that it's a new beginning for over-indebted individuals by allowing them to avail a discharge from their debts. And in doing so, it relieves the debtor of the burden of debt and isolates minimum assets for his subsistence. Actually, we have identified debtors who are in the lowest of the bracket, and also trying to see that they are discharged as quickly as possible so they can make life easy in moving forward, and they can lead the economic life peacefully after this discharging of these debts. So this is very much part of this individual insolvency. You see, and most of you know that Chapter 3 of individual insolvency has 3 components, and the components, one relate to personal guarantors, to corporates. Second is your partnership and proprietorship firms, and third is individual insolvency. So out of these 3, we have only implemented the regime regarding the invoking and trying to link the corporate insolvency with the personal guarantors commitment, so that nobody can get away promising something and trying to get away with the funds not duly invested in the assets. So that part has been addressed. 2E amendment, section 2E was introduced, and personal guarantors issue was introduced in the code. Through this amendment, we bifurcated this personal guarantor regime from other parts of individual insolvency for the sake of implementation. This was challenged also in the Supreme Court, but as the judgment is already out, and it has supported what we did for corporate insolvency regime. Can I go ahead?
Yes, I can join. I have joined. Hello.
Hello.
Thank you very much, sir. It's our great pleasure, sir. Welcome you. Sir, Mr. Sudhakar Shukla, the member of IIBI is currently addressing. He will take a few more minutes and then, sir, we will welcome you. Shukla sir, you can continue.
Okay, sir. So, welcome, sir, in this meeting, and I recall your Ministry of Power, where I was working for some time, and that reforms in electricity and private sector participation and energy reliance, actually, those are the things which we worked out after extensive papers you left in the Ministry of Power, and those were so useful in rolling out the new regime in the power sector. Thank you, sir, for this, because this was some association with you, so I wanted to say in between what I was saying about the individual insolvency. And individual insolvency, three components, and one is fresh start process. And fresh start process, as I said, it defines annual income of or 60,000 or less, assets you have, and debt of 20,000 or below, and you don't have a dwelling unit. So those things have been defined. Who will be availing discharge order under the individual insolvency, under the fresh start, so that the poorest of the poor, if he has taken some loan or debt, then he should not be penalized lifelong from taking any economic activity. So that is why this fresh start process is very important in moving forward. That we have to see how it can be rolled out through administrative order. And in designing the new law, actually, what we deliberated recently, we need three credible inputs. And with these three, after telling these three inputs, I would be stopping for Honorable Suresh Prabhuji to take over. But these three elements which we have deliberated, one relate to how to make it administrative driven process as UK had. Second element which is missing in the code is mediation. So how to bring in mediation so that both parties settle the score without coming to any court or administrative mechanism. And third is a decentralized framework, actually, that India is a very big country, and any solution at the centralized level of NCLT or DRT would not work. So it has to be decentralized solution. So on these three parameters, a lot of churning has happened. And after today's deliberation, we would be benefiting to see that how to roll out the individual insolvency regime in the country. So thank you very much for giving me opportunity to participate in this seminar.
Thank you, Sudhakarji, and ladies and gentlemen, it's indeed a great pleasure and privilege for all of us that we have been joined by Mr. Suresh Prabhu, the Honorable Member of Parliament, a person who doesn't need any introduction, a person who is different from the rest, a person who does the things different from the others. As Mr. Sudhakar Shukla says, he lays down the vision for the future wherever he works. And that vision is that implemented for the growth of the economy, for the growth of India, be it the power sector, be it the railways, be it the trade and industry. He has been a visionary, and not only visionary, he knows how to translate that vision into an action. And that's also very silently and very swiftly. We know the railways, we know the monolithic character of the railways, and what way he thought to bring in the reforms in the administration of the railways. He's by profession, he's a chartered accountant, a rank holder. And sir, before you, Mr. Philip, from the first secretary from the British High Commission, also addressed, and he did also welcome you, and he recalled your contribution in fostering the relationship between the India and the UK. With that, the floor is open for you. Or Mr. Philip, would you like to say something?
No, just big welcome from UK government, Honourable Mr. Prabhu. Over to you.
Thank you. Sir.
I should speak?
Yes, sir, please.
Okay. So I really thank my dear friend Ashok Haldia ji and Mr. Sudhakar Shukla and of course my friends from UK who have supported this initiative, and I can see their very prominent presence in this program. So I am very happy that the organizers have organized this program in such a way that almost all different stakeholders are participating, whether it's the Insolvency and Bankruptcy Board of India, whether the International Institute of Insolvency and Professional of ICA, or the UK government. So I think these are the very important pillars on which the discussion is going to rest, which will hopefully provide a roadmap as to what we really need to do to address this big challenge. As we know, all human beings are prone to make error of judgment. Sometimes they feel that the business is going to grow exponentially, so they invest huge amount of money from their personal wealth, borrow money from the banks, take commercial credit, and on the hope they want to ride on the possibility of the business will grow in a big way in the years to come. The hope is a very good thing, because if there is no hope, no one will be alive. But if there is a hope which is belied and which is defying the normal logic, then the hope can turn into a nightmare. The people who are hoping to have big business will end up into no business, but saddled with huge liabilities. And if that happens, the question is, how do you now salvage the situation? Because if you keep the gun on the head of the person who has borrowed so much, that's not going to give the money back to the creditors. So we have to find some solution to this problem. You can say that was an error of judgment on the part of the person who borrowed, but it could also be the error of judgment on the part of those who lent him the money. So something has gone wrong, and a situation has arisen wherein all these huge debts cannot be repaid by the borrower. And a solution only lies, as we always have in all societies, and this has been traditionally been there, that some people must sit down and find a solution. And over a period of time, with the advent of civilization, with growth of law-based societies, we thought, let's make laws on this subject. How do you declare a person insolvent? If you declare him insolvent, how do you settle his liabilities? How do you take care of his own assets? How do you settle the claim of those who have lent the money to the person who is now going to be an insolvent? And to do all this, a legal framework is in place in many countries. The UK is a shining example of that. Of course, UK is a shining example for many things. It's one of the best rule-based society, law-abiding society, which respects the role and the duties and the obligations and the responsibilities and the rights of almost all the stakeholders. It respects the right of the person who has become bankrupt to live life thereafter, but also respect the rights of those who lent him the money. And they try to strike the balance. And that's how the laws of insolvency have evolved over a period of time. We must be thankful to them, my friends from UK, to participate in this program, to share their insights, and also what could be the roadmap for India. As we all know, India passed a very important landmark legislation, Indian Bankruptcy and Insolvency Code. In fact, I was in the cabinet when we drafted the law. That has provided a very good framework, but largely dealing with, as of now, the corporates and the limited liability partnership, LLPs. That's good enough, because if you really look at the bankruptcies that would happen in terms of value, volume of debt, this is one of the big component of that. But that doesn't mean that we should not cover another important aspect of this. That's the individuals, the partnerships, and how do you deal with them. We have gained a considerable amount of experience by implementing this law, IBC, which has resulted into some very good resolution of disputes which otherwise would have gone on for years. But most importantly, resolution in time is very important. When a company, individual, corporate, non-corporate bodies, they become insolvent, they become virtually unable to pay the debt, and still they have some assets. If you recover the asset in time, there's a very good chance that you will be able to settle the claims in a more efficient manner. If you delay it, there's the erosion of value of the assets. And therefore the liabilities keep mounting because the interest gets accumulated, where the assets values goes down. So timely intervention is very important. And therefore the law should be done in such a way that we must be able to resolve it immediately. I'll give one good example. Mumbai, Ahmedabad, Kanpur, once upon a time were known as the textile centers of India. The textile mills were bringing in booming business. In today's industrial scenario of India, the big contribution to the industrial manufacturing comes from automobiles. But in 60s, it was the textile sector, not only contributing significantly to GDP, but also was a big contributor to the employment generation, big generator. In fact, the economies of the city of Mumbai, Kanpur, Ahmedabad was thriving only because of textile mills. What happened to the textile mills? If there was a bankruptcy law at that time, the value of those assets could have been realized and the textile mills could be still continuing. They could be still operating. But we didn't have the law. We didn't have the resolution method. And therefore we landed into difficulties. The same stands true for an individual. If individual has a problem, but he was an entrepreneur, the first defining factor for an entrepreneur is he is taking a risk-taking person. When you take a risk, there is obviously a downside risk. It can go wrong. And if it has gone wrong, but fundamental characteristic of that individual was he was an entrepreneur. If worldwide entrepreneurship is killed because it involves risk, there will not be any growth. So risk-taking ability is not there with everybody. Those who are taking risk, they must be protected in case of certain situations in which there is an error of judgment on the part of that person or externalities. Some businesses can go down because of some other reason. For example, in Delhi, the Supreme Court rightly decided to close down all the industrial activities in Delhi. What happened to the businesses? They'll go bankrupt. The individual who was running a business in Delhi will not be able to do it anymore. Or look at externalities, like what happened during the pandemic. The business were closed. Tourism business was closed. But the companies or the individual actually who was running a small business maybe still keeping the staff on his payroll. Some countries like UK came out with a very good methodology that even if you keep the payroll going, the government will reimburse you some money. But not all countries could do that, not India could do that. And that means that individual who had taken borrowing and he was paying salaries in a good faith, one can say you are a stupid person, why are you paying salaries? But he was a good Samaritan, paying salaries, honoring his commitment. And now he's faced with a very difficult situation of not being able to pay his creditors. In such a situation, the externalities caused a problem. But just imagine, either error of judgment or externalities, still that person was the person who kept the economic activity going. Because if he had not taken risk, he had not invested, economic activity will never happen. And therefore, we must protect such individuals from such unfortunate situation. And therefore, the law is very necessary. Now, today's IBC, the knowledge that we have gained, or in some cases we talk it debt recovery tribunals, which also function as the dispute redressal mechanism. I think we must find out a way of ensuring that individuals and partnership also will have an institutionalized mechanism to deal with bankruptcies, what we call in parochial language in Hindi, इसका दिवाला बच गया. दिवाला बच गया, लेकिन उससे पहले दिवाली तो मनाता था ना, दिवाली के बाद ही दिवाला हो गया. तो जब दिवाली मनाता तो सब लोग उसमें ऑल वेर हैप्पीली पार्टिसिपेटिंग इनटू दिस. अभी दिवाला बच गया तो सब उसको सलाम करके निकल जाएंगे, और सलाम भी नहीं करके गाली देके चले जाएंगे. So how it can happen? So we must therefore ensure that when the going was good, we'll all applauding him, giving him awards, saying best entrepreneur. And he's going down, we'll say he's a criminal. It cannot be so. If you have done criminally, swindled the money, I can understand. But if there is a genuine bona fide business loss, that must be protected, and therefore there must be a system mechanism to distinguish between the fraudulent activity and a genuine failure. Business can always fail. If the business can succeed, that means there is almost equal chance that they can fail. So failure is the other side of the same coin. The success is never guaranteed, so is the failure is always integrated into the possibility of a success. So therefore we must try to evolve the mechanism. Professionals have to be trained who can then take care of such methodologies, mechanism of dealing with bankruptcies. And therefore this program is a most well-timed program. And I can see the presence of Mr. Shukla and all the top people who are actually empowered with this important part of this process, and very well reinforced by the knowledge that UK is going to provide. I am sure we'll all succeed in coming out with a very good system, mechanism, institutionalized processes to deal with bankruptcies of individuals and partnership. So I wish this program a great success. There is a paradox into this. I'm wishing a program a success to deal with failures. Because what is a failure? The bankruptcy is a failure. So if you don't have a successful program, you will not be deal with the failures. So I hope the program will succeed so that the failures can be addressed. And therefore I only wish a great future for all the bankruptcy people. It is always good parties in life. If, for example, when there is a death in the family, everybody is mourning. But those who undertake the process of carrying out a funeral, they are happy because they got a business. So same way, in this case, when there is a failure of business, the businessman will be unhappy. But a bankruptcy professional will be happy that they has failed because now I can start my business. So it is always a case that one life ends, the other life begins. That's what the law of nature. There's nothing, there's a continuity of life. Either your own or somebody else's. But life continues. So in this case also, I'm sure the life will continue for somebody or other, but will deal with very important aspect, the bankruptcy. But very important part, and I will just end my speech. I don't know whether I'm right. I'm actually not in India, I'm in Bangladesh, but I'm in other program, but I just came out to speak here. As I said, in time, timely action is very important. So if you take an action, don't take action in time, as the money will never circulate, the banks will get stuck, everybody will happen. So resolution in time is very important, and that's why the law must focus on that aspect more. The implementation must happen in such a way that timely implementation is extremely important. The resolution right in time. They always say that justice delayed is justice denied. The same way, if you delay it, probably the person who is now in ICU will certainly be dead. So we don't have to get in any attention at all after that. So thank you very much. All the best to you.
So thank you, sir. A great pleasure and words of wisdom as was expected. And you have set this, the right vision into the minds of the insolvency professionals and the regulators, the spirit behind the individual insolvencies. An individual who is in distress, an entrepreneur who is in distress, he has also right to dignity. he has a right to exit from his stress with the dignity, live the life after the insolvency or the bankruptcy with dignity, and restart and use his entrepreneurial skill again to the advantage of the society and the economy. That's what the theme of your, and that is what I believe is the essential skill and the quality that the insolvency professional needs to imbibe in order to serve the individual insolvency framework in the right spirit. That the triple IPI is the largest IPA in the country with more than 3,000 members, sharing about 60% of the total numbers of the IPs, and the IPs of the triple IPIs are managing more than 75% of the corporate insolvencies in the country. But the individual insolvency, as I said, is a different ball game, require different skill sets, has a different process to some extent, and therefore the capacity building, as you rightly said, of the insolvency professional is very critical to bring to bring back the dignity to the individual who is in stress in time and with the least cost to him. So, sir, thank you very much, and I'm sure this is beginning of your association with the insolvency professionals, and I'm sure your presence and your wisdom would continue to benefit the insolvency and the bankruptcy regime in the country. Thank you very much, sir.
Thank you. Thank you. God bless you all.
Thank you, sir.
Thank you, Dr. Haldia, Shri Suresh Prabhu, Mr. Sudhakar Shukla, and Mr. Philip Sindham for your addresses. Moving forward to today's technical session, we welcome our distinguished speakers for the session. Our first speaker for the session is Ms. Renuka Sane. She is Associate Professor at National Institute of Public Finance and Policy. She has research interest in household finance, especially credits, pension, insurance, and equity market, as well as consumer protection and finance. She was part of the research team for the Bankruptcy Legislative Reforms Committee on the insolvency of individuals in 2015. She is also a member of the Pension Advisory Committee of Pension Fund Regulatory Development Authority. She has a PhD in economics from the University of New South Wales and holds an MA in economics from Mumbai University. Our speakers from UK are Ms. Kanika Kechlu-Connolly, partner with TLT LLP UK. Ms. Connolly is primarily focused on contentious insolvency, fraud, and asset recovery matters, often with a cross-border element. She dealt with both corporate and personal insolvency and has experience of recovery options with particular reference to formal insolvency processes. He has been recognized as a recommended professional for restructuring and insolvency in the corporate restructuring and insolvency space in the Legal 500 directories. Our next speaker is Mr. Rob Armstrong, Managing Director, Restructuring Advisory, Kroll, UK. Mr. Armstrong has over 15 years of experience and specializes in contentious insolvency litigation, providing solutions to creditors and other stakeholders to recover assets, both in UK and globally. Prior to joining Kroll, he was an appointment-taking director at RSM in Special Investigations Team, where he dealt with a portfolio of cases which involved either asset tracing, high net worth individuals, or complex insolvency litigation. Welcome to all our speakers. Over to you, Renuka.
Thank you very much, and thank you for having me here. Is there a way I can move the slides, or will I have to ask you?
Renuka, we'll move the slides for you.
Okay, fine, cool. Thank you. The way I've structured this presentation is I will lay down a little bit of a background for why we need personal insolvency in India. Then speak a little bit about what is there in the IBC in terms of personal insolvency and the kinds of policy questions that it has raised, to which I don't think that we have still arrived at an answer. These are questions that are on our minds, and perhaps we will look at also other jurisdictions to hear their experience on how they have resolved some of these issues. So moving on, the need for, thinking about personal insolvency. Since insolvency is related to credit markets, can we move to the next slide, please? Before we speak of insolvency, it's useful to think and look at how the credit market in India is structured. The first thing that strikes when one studies Indian credit markets is that banks are the largest source of formal credit. And that informal sources of credit are actually higher than formal sources of credit when it comes to an individual. So if you look at individual portfolios, even today, it suggests that more of us are taking loans from the informal sector, such as money lenders and friends and family and shopkeepers, than from the formal sector. And what is also interesting, and this is an important point from the perspective of personal insolvency, is that very few households have both formal and informal sources of credit. And within formal sector, very few households have sources of credit from multiple sources. And that's important because essentially insolvency is to solve a collective action problem. But what you are ending up with are portfolios that are dominated by informal sector credit. And when there is formal sector credit, it is not as if people have multiple sources of borrowing. And this becomes important when one starts to think about the policy framework to resolve stress in individual credit. Next slide, please. I mentioned that banks are the largest source of formal credit, but even if you look at the banking sector as a whole and what kind of loans are banks giving to individuals? So it's difficult to pinpoint exactly what are the loans that are given to individuals from the aggregate data that we see. But I have picked up some headings from the RBI disclosures, which I found in the CMI Economic Outlook database, that are more likely to be taken by individuals or micro enterprises, which would be, self proprietorships and not firms. It is possible, for example, in this heading on trade, that maybe there's a limited liability company that's part of this. But right now, I can't make that distinction. So even if we look at this small segment that is getting loans from the formal sector, we see that bulk of personal loans are collateralized. So within personal loans, there are housing loans and vehicle loans and many other kinds of loans, but all of them are taken basis giving some collateral. It's only largely credit card debt or other debt which is less likely to be secured credit. Then in agriculture, most of these are priority sector lending loans. And again, in micro and small enterprises, I am assuming that these are sole proprietorships. So if you see that in terms of unsecured credit, which is where the role of personal insolvency comes in, the sector is quite small. And most credit to individuals as well, wherever there is formal, is secured credit. And again, this is an important point for us to think about how the IBC will play out, because if most of the credit by the formal sector is secured credit, then how does it interplay with unsecured credit, which is where a lot of the bankruptcy action is likely to be or is designed to be? And how do we think of the interplay between secured credit and unsecured credit in the case of individuals? That becomes an interesting question as well. Next slide, please. Despite this, right, despite the fact that it's very small in the credit outstanding in the case of individuals is very small, we do see that there has been stress in individual credit. So we see that there has been an increasing NPA rate on housing loans or education loans. We see that loans under the priority sector lending, which are largely agri loans, they could be other loans as well, are contributing almost 33% of total NPAs in 2019-20. Then there are various credit guarantee schemes that the government has put in, and they've been around for a long time. There has been an increasing stress on those schemes as well. Several promoters on corporate insolvency have taken personal guarantees, and I think the previous speakers did mention a little bit about how provisions on personal guarantees have been notified in the IBC, and that's very interesting from an insolvency perspective as well. But this is the stress in the formal sector. We actually do not know what is the stress going on in the informal sector because it's impossible to know. And whether, how enforcement happens in the informal sector, whether it's in money lenders or your friends and family, whether there are sort of, ways that you restructure loans or you get ostracized in your village, or there are social costs that you pay. One just does not know how resolution is happening on the informal sector. And finally, over the last decade or so, there has been an increase in loan waivers. So politically also, it seems expedient that you give out loan waivers, especially on agri loans. And that is a bit of a problem because it affects credit culture, but also it affects the way people see discharge. So because loan waivers have been more political, there is a sort of a tinge to how we think of discharge or how we think of what is called a fresh start or the equivalent of a DRO in the UK. Because the assumption is that any kind of discharge like this or any kind of waiver like this will always be problematic and will affect credit culture. And that's coming really from our history of how we have dealt with loan waivers in the past. And again, this is an issue that will come up when I speak about policy issues, because, how do you deal with discharge or how do you deal with waivers becomes an important point in the Indian context. Next slide, please. Why is stress and why is this a problem? Because so far, IBC has not been notified for individuals. So the legal recourse is very limited. A lot of times our hack has been that we use what is the Section 138 of a Negotiable Instruments Act 1881, which is really colloquially known as check bouncing. So you give post-dated checks, and if your checks bounce, then there are criminal liabilities if that happens. And a lot of lenders are using check bouncing as a way to do collection or as a way to do enforcement. And you can see immediately that criminal liabilities on non-repayment of debt is a little crazy and can have repercussions on how we think about risk and debt. Then there is the SARFAESI Act. But it is only for a certain class of lenders, mainly banks, and it is only to enforce secured credit. So we don't know what happens to unsecured credit in that case. In terms of unsecured credit, we've seen coercive collection practices by several lenders. In the early 2000s, it was credit card based enforcement by banks. Then we had seen bad enforcement practices by microfinance institutions. And RBI has correctly come up with several circulars that try to prohibit coercive collection practices. And to some extent, I assume that this has been effective as well. But yet, what is the coercive collection by informal lenders remains unknown because they don't come under the purview of any law. And next slide, please. And what this has meant is really that we have ended up with a credit market where there is a lot of financial exclusion. Because, if there is no way of recovery, then the only way that I will give you a loan is if you can provide me a security. But the minute you start doing that, you have excluded large sections of the market from being able to access credit. It has led to products with high upfront fees, because if you can't recover, then you kind of put the fees upfront and try and make your money while you can. There are effects on borrowers, physical as well as psychological costs on borrowers. People become more risk averse, less willing to borrow. And as I mentioned earlier, that loan waivers have led to fiscal consequences. They have led to consequences on credit culture. And often, strangely, they have had a contagion effect on other lenders. So just because the government announces a loan waiver on one kind of a loan, it almost seems that people take this as a cue to not repay other kinds of loans as well. And that has caused quite a bit of a havoc on the microfinance sector, and which is what makes them wary about some of the debt waiver ideas that we speak of in the personal insolvency case. Next slide, please. So in this context, of a market where there is very limited formal credit, where there is formal credit, but only based on collateral because of very limited means of recovery, brings us to a personal insolvency under IBC. If there were better ways of recovery, then you would have effects on both ends. One, you could make borrowers more willing to take risk. And secondly, you would have lenders more willing to supply credit to borrowers without collateral. And then that's a win-win for the economy as a whole. So with this in mind, the Bankruptcy Legislative Reforms Commission had set up certain objectives when they were designing the personal insolvency sections. So the first was providing a fair and orderly process for dealing with financial affairs of insolvent individuals, effective relief of or release from financial liabilities and obligations, and providing the correct ex ante and incentives. So I think this is, for anybody who works and thinks about personal insolvency or insolvency of any kind, any system will have to think about these things and try and achieve these objectives as it sets about to enforce insolvency. Next slide, please. So currently, what is the eligibility? At least, when the law was enacted but not notified, was that a single default of even 1,000 rupees would suffice, and both debtors and creditors are eligible to file, just as in the case of corporate insolvency. And technically, all kinds of creditors could file. So even money lenders and friends and family could file. So if I was a creditor to my family member and that family member refused to repay me, I could technically take that family member to bankruptcy court. And filings can only be made on debts that are not excluded. So excluded debts are those that have to be repaid and that you cannot ask for discharge, or you cannot ask for restructuring on some of these excluded debts. There are two main routes in the IBC. So one is the IRP bankruptcy route. So this is very similar to the process in corporate insolvency, which is that either a debtor or a creditor files, then you come together and you do an insolvency resolution process. I think it's very similar to the IVA in the UK, with one major difference. I think that in the UK, there are certain thresholds on when it makes sense to do an IVA, because the costs of doing an IVA are rather large. In India, we haven't said anything in the legislation on whether we want to preclude some people from coming into the IRP, but I think that that's an important point that we need to consider. And so the idea is that creditors and debtor will agree on a negotiated repayment plan. And here also the law is rather silent on what would be the priority or what are the rules under which the creditor and debtor will negotiate. One of the reasons why the law is silent is because it was felt that if we specify everything too much, then we leave little room for flexibility and negotiations, which might actually lead to a better outcome. But on the flip side, many have argued that that's problematic because there is, power asymmetry between the creditors and the debtor, and this might mean that the debtor always gets a bad deal. So again, one issue to think about. And in personal insolvency, only if the IRP fails, then you have to file and go into bankruptcy proceedings. You cannot directly go into bankruptcy proceedings. So that's one route, which is very similar. It mimics the corporate insolvency process. The other route is what is called as the fresh start route. And I think, again, this is very similar to the DRO route in the UK. And this provides for debt relief, complete waiver of debts, where individuals below certain income, assets, and debt thresholds can go and ask for a waiver of their debts. And again, there is a lot of anxiety, I think, around the fresh start route on what it might mean and what it might mean to certain lenders, where if a lot of people en masse go and file for fresh start, then what does it mean to the sustainability of the balance sheet of these lenders? And what does it mean to the credit markets, where whether these lenders will go ahead and lend the next time around? So there are certain concerns around the fresh start route, and there are also certain concerns around how we are going to identify people with asset, income, and debt thresholds, because very often when you start looking at that section of society that might be eligible, then finding out the true income, assets, and debt is going to be extremely difficult. So implementing some of this is a real challenge. Next slide, please. There are other important issues. Some of these I mentioned earlier, that secured creditors are permitted to stay out of the IRP entirely by enforcing their security interest, in which case, considering that secured creditors are such a big part of the formal system, how is this going to work, and whether any meaningful resolution can actually come out if the secured creditor just decides to stay away. That's an important question for us to consider. I mentioned that there was no structure on the repayment plan or no priority also, but there is a priority in bankruptcy, and so that's a bit of a problem, because some people might find that it's actually better for them to get into bankruptcy because then they know where on the priority list they are. And the fourth point, or the third point that is important, is that in the case of corporate insolvency, it is the NCLT that plays that's the adjudicating authority. In the case of personal insolvency, as of now, it is the Debt Recovery Tribunal that plays a big role. That's the adjudicating authority. And I'll come to the issues of the DRTs in a minute. Next slide, please. So, given this background, what are the worries or what are the concerns that we have? Next slide, please. This is just the category of potential individual bankrupts in India. This is useful because it gives us a sense of scale. It gives us a sense of who all might be potential users of this law. And so there are farmers, there are microfinance borrowers, small scale industry, that's usually sole proprietorship, personal guarantors, as has been talked about, and consumer finance borrowers who, other than credit card debt, are really borrowing from using secured loans. Next slide, please. So what are the issues that we are concerned about when it comes to personal insolvency? So one is this question of whether we should go through the DRT or if there can be fast track procedures through a non-judicial entity. Now, this raises its own concerns because at the end of the day, since it's about repayment or bankruptcy where you liquidate the assets of any of these debtors, you do need a stamp of a judicial authority. Otherwise, there is no finality to it. So how can you fast track some of these procedures through a non-judicial entity? Where does the role of the administration come in and where does it end, and where do you need the judiciary? Then there are concerns around how to define assets and income. And as I mentioned earlier, for low-income households, it's very, very difficult to know what income and assets there are. Most of these people do not pay taxes. Many a times the assets are owned by the family. Many of the assets are sort of religious assets. And what do you do with such nebulous definitions of what assets and income are? Can you reasonably come up with any scheme where people are going to be happy that there is, that the repayment plan that is agreed upon is fair? Or how do you deal with fraud in these cases? The structure of repayment plans, where there is absolutely, the law is not specifying any structure, was another point. I mentioned the concerns around loan waivers. So there is the process for fresh start. But when you put in the process for fresh start, how are you actually going to implement it? Again, remains a big problem. And how do you ensure that it does not become a political tool like loan waivers had become, but actually is a decision that is made by the individual? That remains a big challenge. Then there are questions around discharge and credit scores. And of course, fees, because a lot of these people are going to be very low income people. And is the process going to be more expensive than the amount of money that is actually, at stake? And then how does that feed back into how do we design a better process for carrying some of these IRP and bankruptcy procedures out? Next slide. The other issue, as I mentioned, was that we have debt recovery tribunals, and I had done some study where we said that even if 1% of the current loans become bad and come to the DRTs, what is the increase in caseload on the DRTs? And you realize that it's going to be huge, and currently the DRTs are not equipped to handle such a caseload. So how do we do reform at the tribunal so that it becomes more ready to deal with individual cases? Another issue is that a large proportion of the judge's time is spent in administrative matters. And what we really need is a tribunal service agency where the administrative matters are separated from the judicial matters. And only when that happens can personal insolvency also move forward, because I don't think however much administration you bring into it, you cannot take the judiciary entirely out of that process. Next slide. Then there is also the question of phased implementation. What should we begin with? And I think that the IBBI has, in my view, done this correctly, where it has first implemented this for personal guarantors, because we'll learn along the way. If we implemented it too soon, then this will become a very difficult problem to solve. Next slide, please. So, I'll end there. I think I just want to make one last point, which is that in the case of India, we need to strike a balance between creditor interests and debtor interests. And the way personal insolvency law has been designed is a little too creditor friendly, and we need to bring back some power back to the debtors. But we also don't want to go to the other extreme where creditors then decide that they don't want to be in this market at all, and we end up with more financial exclusion than what we are starting with. So I'll end here, and I look forward to hearing from my colleagues in the UK about their reflections on the UK system and the lessons they may have on some of the issues that I have raised. Thank you.
Anika, please go ahead.
Thank you, Shivani. Good afternoon, everybody. Thank you very much for having us here today. It's been really interesting listening to the opening addresses, and also Renuka from you as well. We've been asked to present today on personal insolvency and the processes that we have here in the UK, although just to flag, what we're talking about is very much England and Wales. The processes are quite different in Scotland. We at TLT actually have offices in Scotland and Northern Ireland, but those are quite different. So we thought it would be interesting for you to hear from a lawyer, but also an insolvency professional. So Rob's going to cover that side, because it's all well and good having the legal framework and the case law, but there is sometimes a difference between that and what actually happens in practice. So we thought it would be good for you to hear about that. We're going to briefly cover DROs, so debt relief orders, very briefly, IVAs as well, so individual and voluntary arrangements, and bankruptcy. So looking at the key elements of them, and critically for you as the audience, the role of the IP. Just at the outset, it was mentioned in some of the opening addresses about the Insolvency Act 1986. You'll be aware, obviously, of the that is our main act, and it's one that Rob and I have both grown up learning about and living with and putting into practice. Very recently, in 2020, last year, there was a new act, but that's very much aimed at corporate, so not necessarily relevant for today's discussion. But to supplement the act, we also have our insolvency rules 2016, and we also have various practice directions, so much smaller statutory instruments, but which provide a lot of detail in terms of, we'll come on to it when we come to bankruptcy, the processes that you need to go through for statutory demands, for bankruptcy petition, personal service, all of those kinds of things. And from Rob's perspective on the IP side, he'll deal with this in due course, you have what's called statement of insolvency practice as well. So guidance basically for IPs on how to do their job effectively. I've put up here on the slide, I thought it may just be of interest. It's a graph, and I don't know how well you can see it or not, but that comes from the Insolvency Service, so the government, and it shows in yellow the individual voluntary arrangements, in, I don't know, burgundy maybe, the bankruptcies, and the black line at the top is the overall individual insolvencies. Now, I think what's interesting is the fact that the IVAs very much appear to be on the up, and bankruptcies seem to be dipping, and that could be reflective of the kind of debt that we're seeing out there. Obviously, COVID has had an impact as well. The DROs were only introduced in 2009, which is why they've only started from there. But I just thought that graph was quite a good way of just kicking off. So looking at debt relief orders, if we just move to the next slide, this is not something that Rob and I actually really deal with, mainly because they are very low value, but we just thought for completeness we would deal with this. So essentially, it is a process which allows a debtor who has very low value assets and negligible income to get a release from their debts. In terms of thresholds, it used to be until very recently, I think it was June or July this year, but it used to be the level of debt had to be below £20,000. And that's actually been raised now to £30,000. So as I say, that's quite a recent change. And they have to have assets with a value of less than £1,000 and disposable income of less than £75. So, you know, really talking very minimal amounts. It's a very paper-driven exercise. It's made by way of an application through to the official receiver, so the government body effectively. There are various intermediaries, like Step Change, you know, organisations who are tasked with helping the debtors to fill in the forms, etc. It essentially provides for the debtor to be given 1 year protection from creditors to stop them enforcing their debts without the court's permission. And effectively at the end of that year, the liabilities are wiped clean, so the debtor starts with a clean slate. They're very different to what we'll come on to talk about. There's no realisation of assets, there's no investigations, there's no claims. It's just a very straightforward process for people who fall within the criteria to be able to move on with their lives effectively, which has been, you know, some of the comments that have been made this morning already very similar to that. There is a process to object. As a creditor, you can also ask that your debt not be included within that. But as I say, because of the sort of values that are involved, it's not something that Rob and I necessarily deal with, but we just thought it would be good to highlight it here. So as I say, you can object if you think as a creditor there's been a significant omission or error in terms of what's stated in the proposals, or that, you know, the official receiver was wrong to suggest that it was a case where a debt relief order would be the right thing to do. So I think moving on to IVAs. What is an IVA? I mean, it's essentially a contract between the debtor and his or her creditors. So they're very bespoke. Having said that, there are a whole host of templates that are available. R3, which is one of the insolvency bodies here in the UK, they have precedent templates available. A lot of the law firms, like a lot of the accountancy practices, and IP firms like Rob's, for example, will have their own precedents. So there's a lot of boilerplate clauses, but essentially it is a contract negotiated between the debtor and creditor, and I'll let Rob come on to talk about the drafting of that very shortly. It's fair to say there's an incentive on the debtor to be full and frank with his or her disclosure about the assets that are being included in an IVA. The reason people go for IVAs, or one of the reasons, are that they want to avoid bankruptcy. So they should be doing the best they can to ensure that it's as complete as possible, and frankly is as attractive as possible to the creditors to ensure that it gets voted through, because otherwise the alternative is likely to be bankruptcy. They tend to last between 3 to 6 years, so can be quite long in the tail, and that can sometimes be due to the types of assets that are included, for example, in the arrangement, but also the period of time it's going to take to get to a position where the creditors are getting the amount that has been agreed upon in it. Secured creditors, they can be bound with their consent. And I mean, Rob will come on to it when we come to voting, but you need 75% of your creditors to have a proposal approved. Rob, I don't know if you wanted to maybe deal with the proposals.
Yeah, thanks, Kanika. Yeah, the proposals themselves, and this is where Kanika was saying earlier, that there's a slight difference between what's written in statute and the law and what actually happens in practice. So the proposal itself is a document which is meant to be drafted and put together by the debtor themselves for the approval of their creditors. But in actual fact, what happens is they are drafted by an insolvency practitioner on behalf of the creditor, who then affirms that they're correct and accurate. The proposal documents themselves are quite large, usually in practice. They cover the kind of historical reasons for the position the debtor is in. They have to detail all of the assets which the debtor has and wants to be included, and for that sake excluded from the proposal. The period that the proposal is going to run for, and effectively why that proposal is better than the alternatives, which could be bankruptcy. So the document is effectively drafted on behalf of the debtor, but with them consenting and confirming that it is an accurate reflection of the position that they are in. Within it obviously accounts for what they can afford to put to their creditors as a full repayment of the debt. And there is obviously in that an element of debt relief. It's typical in the UK that proposals that are put to the creditors may be somewhere between 5 pence in a pound and 25 to 30 pence in a pound, depending on the level, the value, and the asset position of the debtor. So, I mean, they do account for a large write-off of the debt that is due to the creditors. So, say sometimes up to 75% isn't unusual, but it can be more, especially in respect of where there's limited assets, and you're talking about the compensation to the debt to the creditors actually being from future income, so salary contributions from the debtor over a period, as Kanika says, sometimes up to 6 years. The alternative to that may be a bankruptcy where they actually get no assets, especially after fees have been taken out. So a meeting would then be called. The proposals are put to the creditors. It's very much a contract between the debtor and the creditors. It's an agreement where they reach it together, but it's bound by law. So the debtor can put whatever they want in the proposals, as long as it is a true reflection. But the offer that they are making to their creditors and the limits and what they're saying they're willing to repay is entirely up to them. Obviously, if that amount is unacceptable to creditors, then they don't have to approve the proposals. So that comes down, as Kanika was saying, the voting proportions. So you require 75% of unconnected parties to vote in favour of the proposal, 50% effectively of those that are unconnected as well. So there are actually two forms of voting. There is one for connected parties and one for unconnected parties. So it's 50% for unconnected, 50% including connected, 75% unconnected. So the purpose of that is so that you can't have a family member or a company where, you know, it might be the individual is a director of voting through a proposal which other creditors may not be happy with. The creditors themselves don't actually have to accept the proposal that's put to them. They can seek modifications to it. One of the main modifications you'll see through in the UK is HMRC have their own set of modifications that they require of any proposal that's put to them. So they will have sort of a preset set of modifications that they require to ensure that their position's set forward, and some of the other banks do as well. And effectively they just agree, you know, as long as these conditions are met, we're happy to vote in favour as long as the percentages are the correct amount and we think it's equitable. So again, that's something which over practice has kind of developed, and you do expect to see that from certain groups of creditors, that they won't forwardly reject the proposal, but they'll say they will vote in favour as long as these modifications are added to it. Any modifications which are voted through obviously then affect all of the creditors as one. The proposal binds everyone, whether they voted in favour or not in favour, as long as the requisite voting numbers are met. So you do have this situation where you have dissenting creditors who are bound by the terms of the proposal as long as you get 75% voting in favour. The role of the IP in respect of an IVA, sorry, just go on to the next slide, is split into two. You have the nominee role, which is up until the point of a meeting and a proposal being implemented, and then post implementation, the IP becomes a supervisor. The role of the nominee is, in law, it's to review the proposal that's being put to them by the debtor, to check that it's fit, feasible and fair. So this comes down to what onus is on the IP to effectively check what is in the document. They're not meant to go through the document and check whether there's been any material omissions. They are purely meant to do a sense check. They are meant to meet with the debtor to ask the requisite questions. They're meant to check that the debtor is an appropriate person to put an IVA document forward to their creditors. And this again, Kanika touched on this, statement of insolvency practice effectively says that the IP is meant to check that this is the appropriate process for them, and either a debt relief order or a bankruptcy process wouldn't be better than an IVA. They are then meant to check that the proposal themselves are likely to be approved, and also that they're likely that the debtor is likely to be able to comply with the terms that they're putting forward. So if it is saying that they're going to deal with this proposal over a 6-year period, and they're going to contribute money which the IP thinks is beyond their means, then they should recommend that the proposal is not put to the creditors. So there are some checks and balances at this point, and as I say, the onus is on the IP there to do that work. In respect of fees, that is something that at that point which is expected to be paid by the debtor coming to see them to put this proposal forward in the UK. So there is a nominee fee which is paid by the debtor. I'll come on to the supervisor shortly, but the supervisor's fee is usually taken from the assets, the contributions which are made. And again, how those fees are taken, at what time, and what period is all something that's detailed within the proposals and agreed by creditors. So just coming on to the role of a supervisor, the main role of the supervisor is effectively to monitor the implementation and the proposal going forward. So whatever is set out in a proposal and agreed by creditors, whether that's collecting assets at a certain date, selling property, effectively checking that contributions are being made and taking fees, is all something that has to be adhered to. If regular contributions aren't met, if there are properties that should be sold by a certain date and there are not, or indeed third-party contributions which do not come in, then these could be, under the terms of the proposal, a breach and an event which could lead to the supervisor being required to petition for the bankruptcy of the debtor. So again, all of that timetables, whether there's a period where the debtor is allowed to rectify any breaches of the proposal, and sometimes that again is normal, that a missed contribution, they may have 1 month period to be able to make that up before the supervisor will be required to petition. But again, all of those details are set out in the proposal doc, and this is why they are quite complicated documents and usually not put together by the debtor themselves, although that is the provision within the law. The assets which are being held by the supervisor do not automatically form part of a trust asset for the benefit of those who have effectively voted through and are bound by the IVA. There is case law behind it, which suggests that should be the way they're treated, but it usually is dealt with within the document itself. So should there be a failure of the IVA before the full term is reached, it will usually provide whether those assets then need to be distributed pari passu to the individuals who are, or the creditors who are bound by the IVA proposal, or whether they get passed straight across to the bankruptcy trustee who's subsequently appointed following the failure. So again, that's something to bear in mind, especially if there's subsequently a loss of assets which are being held by the supervisor. I just touched on it there, but the failure of an IVA, obviously these are long processes which can go on to sort of 6 years. Circumstances change for the debtors. Sometimes they're in a position to be able to pay off and make contributions quicker. Other times, maybe they lose their employment, or properties which they were going to bring into the IVA, the value of them drops, and it means that they're not able to reach the contributions that they've said they're going to be able to. So it is not uncommon that an IVA will fail partway through the process itself. And as I say, that the usual remedy for that is that the supervisor themselves would then petition for the bankruptcy of the individual, and they'd use the assets within the estate to effectively pay for that petition. The process would then move across to a bankruptcy, and it would be usual that the supervisor of the IVA would then become the trustee in bankruptcy for the individual. If we could just go on to the next slide. As I say, the proposal document itself is something which the debtor puts together themselves, which does give them quite a lot of leeway, different from a bankruptcy, where they can actually pick and choose which assets of theirs they do want to include within the proposal. So in the UK, one of the main reasons why people seek to agree an IVA with their creditors is for the exclusion of the matrimonial home. So the process would usually be that they would get a valuation for that asset, or any asset they wish to exclude. They would disclose the value and their share of any equity in that asset, and effectively agree to compensate the creditors by introducing a different asset which would sit outside of a bankruptcy process, such as third-party funds. So whether that be a cash receipt from a company, or a spouse, or a parent, as I say, something which would be out of reach of a trustee in bankruptcy, which can be introduced for the benefit of the creditors within the IVA process. But as I say, it doesn't necessarily mean it has to be the matrimonial home. It could be anything, tools of the trade that they need to work, or pensions which they could introduce, which otherwise would fall outside of a bankruptcy process in the UK. I think that probably pretty much covers the IVA process for me. Do you just want to go across the advantages and disadvantages, Kanika? I think you're on mute, Kanika. So.
There you go. Like we said, it's the type of cases that you see IVAs in are a lot of consumer credit type cases. But also, interestingly, high net worth individuals. And one of the reasons for that is, as Rob was saying, that seeking to exclude the matrimonial home, for example. Here in the UK, you have what's called IVA factories. So there are firms who churn a lot of these IVA documents out, because, as I say, you have a bog standard one, which you can then adapt depending on the case, so that there are firms who on a monthly basis will be doing hundreds of these. It's fair to say there are advantages and disadvantages for both debtors and creditors. You'll see for the debtor, and as I said earlier, there is an incentive for the debtor, because it avoids bankruptcy, which we'll come on to, and the impact of bankruptcy, which can be quite significant depending on what the debtor's trade is, for example, what their job is. Disadvantages, obviously, it impacts on your credit score, but frankly, any of the insolvency processes are going to. It lasts longer than bankruptcy. Bankruptcy, you can be discharged after 12 months. So those are the sort of downsides for the debtor. On the creditor side, I mean, Rob gave you a bit of an insight there into returns, 10, 15, 20, 25p in the pound. So significant haircuts, significant compromises. Those numbers aren't unusual. And I think it's well worth bearing that in mind, but there is something to be said for the creditor doesn't have anything at the moment. So to a certain extent, it's better to get something rather than nothing, draw a line and move on. Disadvantage, and this is very much the kind of work that Rob and I do, is on the investigatory side. So that tends to be for the more complex cases where debtors have assets cross-border, for example, lots of different jurisdictions. You won't get any investigation into their affairs to try and locate more assets in an IVA, which you would do in a bankruptcy. So just something else to bear in mind. I think maybe if we move on to bankruptcy, now. Robert, do you want to pick up on the debtors petition first?
Yeah, I think just picking back where we were with IVAs, I said, IVAs aren't actually appropriate for every debtor, and the UK provides a route for debtors who still do want to take control of their affairs and don't want to wait until someone petitions for their bankruptcy. So there is a debtors petition route in the UK where a debtor can go to court, can pay a fee, and can effectively make themselves bankrupt. They have to be able to show that they are in the right jurisdiction, that establish that they this is their centre of main interest, and that effectively they are insolvent. I think the fee these days for making yourself bankrupt is about £1,200. So it is quite expensive, but that is the cost effectively of the court process and the insolvency service picking up the file. The reason why debtors would choose to go down this route rather than effectively going through an IVA is one, either they have limited assets, but their debts outweigh those which are suitable for a debt relief order, but they're unlikely to be able to reach a compromise, or that they have particularly unsupportive creditors who will want them in a bankruptcy process with more oversight, more investigation powers that a trustee has. So they're the main reasons really why people go down this route. It's not as common as a creditor petitioning for a bankruptcy, but it does happen. The process itself is obviously that they attend court on a certain day when there is a debtor's petition hearing. They file a number of forms which they can do online, and the order is effectively made there and then, and the file gets passed to the insolvency service, who automatically become trustee in bankruptcy at that point, the official receiver. There are certain circumstances where this process is sometimes abused within the UK. And that is where there are individuals outside of the UK who want to move to a more favourable debtors jurisdiction. And this happened specifically during the last financial crisis in 2008, 2009. There are a lot of individuals who moved across from Ireland to avail themselves of the bankruptcy process in the UK. And before that, actually, in 2005, after the Enterprise Act came in, there was a number of German tourists who came across and availed themselves of the same process. And that's because of the Enterprise Act in 2005 effectively means that you're only bankrupt in the UK for a period of 12 months. All of your assets and debts fall into your estate, and you are relieved of those liabilities and obligations after that 12-month period, unless your discharge is suspended. So, I mean, that is something to consider. That you do need to have the right checks and balances, that the individuals who are using these processes are proper Indian nationals, if that's where you get to, and that they are in the right jurisdiction to be able to use the tools which will be on offer to debtors.
I think just moving on to the creditor's petition, and I suppose the kind of cases where we see this is judgment debtors, for example. So if you're a claimant, you've got a judgment against a debtor, an individual, and they're not paying up, those kind of cases. Also guarantors, and obviously we're aware of the enactment of the RBC for personal guarantors of corporate debtors. And so that's very much the kind of cases where we would use personal insolvency and bankruptcy. As I mentioned earlier, the detail of the steps that you need to go through in order to comply with the formalities is set out in our Act, but more so within our insolvency rules. So there needs to be the service of a statutory demand, which is effectively a formal demand on the debtor, which gives the debtor 21 days to make payment. Absent any payment, the creditor is then able to pursue a bankruptcy petition. There is, however, a mechanism for the debtor within 18 days of service of the statutory demand to make an application to set aside the statutory demand. And that effectively is in circumstances where the debtor disputes the debt. And I should have said at the beginning that actually the threshold for bankruptcy is £5,000. It was increased a few years ago. So you do need to have an undisputed debt of at least £5,000 in order to be able to present a stat demand. The rules require personal service. So we here in the UK would use process servers. So individuals who are tasked with going and tracking down sometimes the debtors and actually personally serving them with the documents. The process server would then fill in an affidavit to confirm that they have served, where, when, how, etc. And that's something that you will need in due court to evidence to the court that you have ticked all the formalities. Moving on then, on the assumption that the stat demand has not been satisfied, there's been no application to set aside, you would then present a bankruptcy petition. In the same way, personal service is required, and that's to ensure that documents have come to the debtor's attention, because clearly the consequences are draconian and very severe. So the courts want to ensure that the debtors have had whatever opportunity they need in order to deal with the matter. As Rob said, the fees are actually quite high. They're just shy of £1,300 at the moment, which needs to be paid when the bankruptcy petition is issued. When a petition is issued, it's issued at court. I'm sorry, I should have said that the statutory demand isn't, so it's not a court's document. There is, if in the UK the debtor owns property, we have the land registry here where all the details, titles effectively are dealt with. When a petition is presented, there will be a restriction which automatically goes on if there is property owned by that debtor, which says that there is a pending petition. So that's a protection to ensure that the property doesn't go anywhere. There will be a court hearing where the debtor is given the opportunity to defend, for example. But ultimately a bankruptcy order will be made, and if it is made, it's very precise in terms of, the order is made at 3:42 on this date, and the official receiver will automatically be appointed as the trustee in bankruptcy of the debtor's affairs. Now, in some cases, the official receiver will remain as trustee in bankruptcy. They tend to be perhaps the slightly more straightforward cases where there might not be that many assets. There might not necessarily be cross-border elements, so assets in different jurisdictions. There may be no need for complex investigations. Those tend to be the kind of cases that the official receiver would deal with. Alternatively, the official receiver would seek the appointment of an independent trustee in bankruptcy, such as Rob, for example, who would come in and take on the role of trustee in bankruptcy. I think moving on to the next slide, maybe.
Yeah, right, I'll take this, Kanika. Thank you. The powers of a trustee in the UK are actually they're pretty strong from all of the insolvency processes. It's probably I'd say it's something that was established over a long time, and in some ways they're quite draconian still. So an example of some of the orders that a trustee in bankruptcy they can actually still get delivery up of passports. They can get full disclosure of any party who's got any information in relation to the bankrupt. They can request and compel that the bankrupt attend before the court and be interviewed. The main use of the powers in the UK is one, to investigate any assets which have not been disclosed by the bankrupt themselves. It's to obtain and get in all records which relate to the bankruptcy estate, and really just to ensure that all the assets are being dealt with and recovered for the benefit of creditors. The trustee also is able to effectively go outside of a jurisdiction to enable them to deal with any assets which sit outside. We can use the Union's trial model law to kind of go to any jurisdiction now, seek recognition of the UK bankruptcy order, and effectively avail themselves of the same powers that they would have in the UK to try and recover the assets there. Which is obviously in a world we live in now means that a bankrupt can't place an asset outside of jurisdiction and expect that they'll be able to keep it post the bankruptcy proceedings and be able to carry on effectively without having to account to their creditors for that asset. There are a number of provisions within the Act itself which deal with specific antecedent transactions. These are in relation to transactions which have happened in specific time periods in the way leading up to the bankruptcy itself. These include transactions at undervalue, which might be a gift to a spouse, or selling an asset for considerably less than it was worth within the immediate run-up to the bankruptcy. A preference, which is effectively preferring one creditor over another. So repaying a debt to an associate or a family member in a lead up when the pari passu model should have been adopted at that point. So those transactions can be cancelled and effectively the assets returned to the estate for the benefit of all creditors. The investigation tools which an insolvency practitioner and a trustee have, again, are large. So you can actually seek orders from third parties without notice to the bankrupt. So any person they're dealing with, there is an ability to go and get orders for delivery up and disclosure of certain documents, which means that investigations can be done without tipping off third parties to what you're actually looking at. The recovery of anything that's within the debtor's name, effectively. So if they're instructing third parties, professionals, you can go ask their solicitors, their accountants, obtain their tax files. So it can give you a really good picture of their asset position without having to rely on what the debtor is telling you in interview, or indeed put in their questionnaires to the official receiver. Should it become apparent that the debtor is not cooperating, not disclosing assets to either the official receiver or their trustee, then there is an ability to go and seek a suspension of their discharge. So as I said earlier, the period of a bankruptcy in the UK is 12 months, and it is always 12 months. But what can happen is you can go to court, seek a discharge, and effectively the clock stops running on that 12 months. Now, that might be for a specific time period, or it might be until they comply with an order of the court for delivery up of certain information. And only on a return date will the clock start running again. So whilst the period of a bankruptcy never exceeds 12 months, it can be indefinitely suspended. So until that suspension is stopped, the clock doesn't start running again. So effectively, you can be bankrupt indefinitely, but on completion of whatever the court order was, however long was left on your bankruptcy would then continue ticking down until the point when you would receive your discharge.
And maybe Rob, just a point to make on that. I mean, the instances in which we would consider suspending discharges, as Rob says, when there's a lack of cooperation maybe from the debtor. And I suppose that the sort of stick used is the impact of bankruptcy on the debtor. So it could be that, they're not able to act as a director of a company, they're not able to get credit. If they're a regulated, if they're a professional, for example, it impacts on that. So it's thinking about in individual circumstances whether there is any benefit in seeking that discharge or not, because even though you get discharged as the debtor after 12 months, the trustee in bankruptcy will remain in office beyond that in circumstances where there continue to be assets to be realised and investigations to be done. So that job doesn't stop after 12 months. Just to clarify.
And I would say just on that as well, Kanika, you have after acquired assets as well. So for the period that the bankrupt is effectively in bankruptcy still, should they receive an inheritance, win the lottery, effectively become a new asset becomes available to them while they are bankrupt, that can be claimed by their trustee in bankruptcy for the benefit of their creditors. So having that suspended period and effectively moving it beyond 12 months where you're dealing with someone who is not cooperative and is potentially not disclosing assets can be very beneficial for the creditors and the trustee. The other, just touching on assets themselves, income payments, orders and agreements are something else which can be used. So I spoke earlier about individual voluntary agreements where effectively contributions can be made from salaries. That is also available in a bankruptcy procedure where the assets are sufficient to mean that there's a surplus available to the bankrupt. So any monies above what they need for their living expenses should then be remitted into the estate for the benefit of creditors. Those income payment agreements and orders typically last for 3 years. And as I say, if it can be reached by an agreement, that is a voluntary procedure where they state their income and their outgoings, to the trustee or the official receiver. If they are unwilling to sign and agree voluntarily to that, then an order can be sought from the court. Just more generally on assets, there are some excluded assets in a bankruptcy in the UK. So pensions sit outside of a bankruptcy procedure, as do things for general household items, cars which are below a certain value, and tools of trade, anything they need to work. None of those sit within a bankruptcy. Anything else effectively does fall within the estate, and it is the responsibility of a trustee in bankruptcy to go and realise that for the benefit of creditors, bring the assets into the estate. They would then need to have their fees approved by the creditors. And that basis in the UK is usually either time costs, it's on a percentage of realisation basis, or there is the OR scale rate effectively, which can be relied on.
And it's probably worth noting that it's an automatic vesting of the assets as soon as the trustee in bankruptcy is appointed. So there's no requirement for documents of transfer or anything. It's just as soon as the bankruptcy order is made, those assets automatically vest in the trustee in bankruptcy. And just to say on the home, so the dwelling house, there is a time limit. So although that does automatically vest in the bankruptcy estate, if no steps are taken to realise the bankrupt's interest in that home within 3 years, then it effectively revests in the bankrupt.
Brilliant. I think that's probably taken us through the different regimes which sit in the UK for personal insolvency. Kanaka and I would be happy to take any questions if there are any.
Thanks, Rob, Kanika, and Renuka for that informative session. So the participants can post their questions in the chat box. And in the meanwhile, I'm taking up the questions that I've got. The initial few questions are for the UK speakers. My first question is, what is the role of judiciary and an IPIN, IVA, DRO, and the routine individual bankruptcy process? Could you please clarify for the benefit of our participants?
So for a DRO, there isn't any involvement of the judiciary. It's a straightforward sort of administrative process. The idea is to very much keep things out of court. So that's why that is. Bankruptcy, there is the bankruptcy hearing. You will also have significantly contested bankruptcy matters. For example, we act on the Vijay Mallya bankruptcy, for example, so that's taken many years to go through the courts. So it will depend. The judiciary is important as well for the development of case law. So Rob spoke earlier about pensions that fall outside of the bankruptcy estate. That hasn't always been the case, and that's something that's changed as we've both been in this industry. It used to be part of the bankruptcy, it fell out of the bankruptcy, it went back in, it's fallen out again. So definitely have to keep on top of case law.
Sure, thank you. Are there any restrictions imposed on an individual who has been declared as bankrupt by UK court?
Yeah, there are a number of restrictions. Yeah, there are normal restrictions when you are placed into bankruptcy to start with. As Kanik said, you're not allowed to act as a director of a limited company. You're not allowed to act as a member of parliament. You're not allowed to incur credit of more than £500 without telling the creditor that you are an undischarged bankrupt. So yeah, there are a number of restrictions. Also, it does obviously affect your credit rating for 6 years. There is a power. One of the things that happens on bankruptcy is that the official receiver of the Insolvency Service actually investigate the circumstances which led to the bankruptcy, and if it's deemed that the bankrupt was effectively reckless in their actions and contributed to it themselves, then there is a bankruptcy restrictions order that can be sought, which extends those restrictions for up to 15 years.
Thanks, Rob. Could you also please let us know what is fast track voluntary arrangement under the insolvency bankruptcy?
So that's something that comes in after you've been made bankrupt. So different to an IVA, which you try and do before bankruptcy and as an alternative to bankruptcy. A fast track one is actually if you're in bankruptcy and you've decided actually there's a better way out of this, then it's a separate mechanism to do that. But again, they tend to be for the smaller value type cases, and it's dealt with by the official receiver. So it doesn't apply, as far as I'm aware, in circumstances where an independent trustee in bankruptcy like Rob would be appointed. It's only available in circumstances where the official receiver remains the trustee in bankruptcy. So those more straightforward cases.
Sure, Kanika. Is there a dedicated role for COC to play in individual insolvency like we have for in corporate processes?
Yeah, the COC isn't as big or doesn't have as big a role to play over here in the UK as it does in India. I know the Committee of Creditors has a big say over there. There are actually very few cases here where you have creditors committees. I've just stepped down from one actually. So they happen, they exist, they tend to be on the much larger cases. You would sometimes have a creditors committee when you've got a lot of different investigations to do, a lot of different claims, and you effectively take a steer from the creditors committee on what it is that they want looked at, what investigations they want run, because effectively any work that is done keeps depleting the asset pile because costs are being incurred, and so it impacts on the creditors overall. So that's where there is that interaction with them. But it's fair to say that they're few and far between. Rob, I don't know if you've got any cases where you've got committees on at the moment.
Yeah, I do have committees. I think the general point is where that they're very complex, or there's large groups of creditors, and effectively giving updates to all of the creditors becomes quite burdensome on the IP, and it's easier to have almost a steering committee of a smaller group which are able to inform the trustee as to what actions they want to do. Sometimes it happens in cases where there might be funding that's required by the trustee to take certain action, and so the creditors are actually putting forward that funding with the view to kind of releasing more assets in the future.
My next question is there any preventive mechanism for fraudulent initiation of individual insolvency? Preventive mechanism? Is there any preventive mechanism for fraudulent initiation of individual insolvency?
Someone seeking to make themselves bankrupt when they shouldn't?
Yeah.
Well, as I say, actually in the UK, there's a requirement to fill in a form which is it's a document that they swear, so it's actually a criminal offence to lie on that document in the UK. The other is that certainly not all, but sometimes you do actually have to stand before a judge in the UK when making yourself bankrupt, and they can ask questions, especially if it's that's usually the case if it's high value. If the creditors of the individual are seriously above the normal that you'd expect to see, then a judge may say you need to come into court and explain this and talk us through why you need to be bankrupt. So there are some checks and balances. There is an onus on, as I say, on the debtor, and you do then have the bankruptcy restrictions orders that can be imposed on them if they do sort of lie during that process.
Thanks, Kanika and Rob. That's all I had for the UK speakers. I have a question for Renuka as well. Renuka, could you please highlight how is the personal insolvency resolution different from a personal insolvency bankruptcy?
I think I've typed my answers here already. Somebody asked them in the chat box, which is that resolution is more like a restructuring, whereas bankruptcy is where we liquidate the assets of the debtor.
Yeah. Thanks. Thank you so much. With this, we come to an end for our session. Mr. Madan, Mr. Shukla, thank you for joining us and giving your addresses. So, would you have any questions to ask our speakers?
Let's see if Shukla sir wants to have some concluding remarks. But from my side, I think fantastic discussions. Thank you, Renuka. Thank you, Kanika, Rob. One of the interesting session, and I'm sure our participant would have learned. Shukla sir has joined back. Any concluding remarks, sir? Over to you.
No, actually, I have not left for a single minute. I was in the entire discussion. But only point I thought I was, and both Renuka and also others, basically, what Renuka pointed out about the informal channels of debt here in India, and it's a very problematic area to go into. While like UK has evolved over a period of time to hundreds of history, so informal debt was in reckoning any time that how they were this insolvency, individual insolvency regime should informal debt. I think Kanika.
Your voice broke in between, sir. Can you please repeat your question?
No, I'm saying that Renuka was highlighting about the informal debt regime in the country. It's a predominant space is still by informal channels coming into debt market. So individuals are not availing organized debt instruments. So how this insolvency regime which comes can discriminate between the organized debt channels and the disorganized informal debt channels? So that was my question. Basically, if Renuka can answer, but that is the problem she raised actually.
If I were to just, my view is that if we really want to bring in informal channels in insolvency, we need to solve the problems of supporting institutional infrastructure like law enforcement in the country. So, if a money lender has to be brought into a IBC, then we need the courts and the police to work so that he's actually, following rule of law. So it's a tall order for us, but I think that, as the market evolves, and the formal sector market evolves, it'll take us some time to get there, but we surely will.
Yeah, because even the numbers, if you see the graphs shown by the presenter from UK, like 100,000, 120,000 cases in a year being settled. So we are still talking about 4,500, 5,000 disposals in entire 5 years. So you can see the difference actually when you open up this channel, individual insolvencies, number would be rising humongously. And that is why when I said I would be preferring the administrative channel, that was basically tick-based approach, that you tick mark what is available, not available, and then you discharge or orders are passed based on the quality of asset individual is having. So that was the kind of thing in my mind, but that we have to see that how it evolves. But I'm grateful for these 3 presentations, and we look forward again that such programs would be happening. In around 200 people have joined online. So they had some questions already, and thank you very much for joining us. And it's a joint conference at IBPI, IIIPI and FCDO, and we will continue to host such kind of programs in future as well. Thank you very much.
Thank you. Thank you, sir.
Thank you to all our speakers and our participants for joining this session. And in fact, over the period of time, over 500 participants joined today's session. So thanks to all of you for your guided background on the important topic that India is looking forward to. Thank you so much.
And thank you, team from EY, especially Shivani and team Sanjana. Thank you, and we look forward to more such programs in the future. Thank you. Good day.
Sure, sir. Thank you so much.
Thank you.
Thank you all.